Are you serious?
This matter is concluded. You're free to go.
Who's around here?
Hold,
No,
ma'am,
seriously.
Another 30 days for contempt of court. You're in jail for 60 days now.
No.
Evil ex-wife got husband arrested, then lies to the judge and instantly regrets it.
She's accusing him of sexually molesting these girls. But before all this, she's wanting him to come home. She's wanting a relationship.
This ex-wife made fake allegations about her ex-husband accusing him of child abuse and said some terrible things in court. When the judge figured out her lies, she got served with karma. Here's how it went.
Good morning to everyone. This time and place set for the show cause hearing in this matter for failure to provide parenting time. I'll let everybody know that everybody will have an opportunity to speak. So,
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to compliance with the court order and my client getting parenting time. It's directly impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to this. He's having a hard enough time in the present, again, because she's not keeping in compliance with the court order, and he's not able to see these girls to be able to have a solid relationship and foster that relationship. The length of time they've lived in a stable, satisfactory environment, I'd submit to the court, defendant's home is not stable, considering the allegations she's made that have been investigated by CPS twice, police twice, and both been denied. Nothing's come of it. Which leads me also to the moral fitness of the parties involved, which ties into the same factor. We have to keep in mind, Your Honor, at the beginning of this case, he was charged with domestic violence in relation to her essentially going after him to get keys to his truck so she could get some pot and smoke it. As he's being arrested, she's telling him, "I want you to come home." He, of course, gets him on bond. He can't have any contact. Once the bond conditions get lifted, she's contacting him through text and saying, "Hey, let's meet you and the girls get together and we can go to the zoo, we can go to a park." She's accusing him of sexually molesting these girls. But before all this, she's wanting him to come home. She's wanting a relationship with him. She's wanting her family essentially reunified. Those two things don't jive together, Your Honor. And I would think that essentially it's a fabrication, which would go again to the moral fitness and also to the mental and physical health of the parties, Your Honor. You're making these allegations, these terrible allegations, but on the other hand, you're still wanting the same guy who's supposedly doing this stuff to come into your house. Finally, Your Honor, the unwillingness and inability to facilitate and encourage a relationship. Again, this is the fourth motion we're here this morning on, Your Honor, for him to see his girls. She doesn't follow your court orders. She withholds them for no valid reason. And she's clearly shown she's not gonna facilitate a relationship between him and his kids. I think that's more than enough that gets us over the threshold of a change in circumstance or a proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So we would request, as part of our relief, that you set this matter for an evidentiary hearing. We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing. That mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's going to take these kids and run, and we're going to be in a bigger mess than we are today.
okay, thank you. Ms. Couch, if you wish to speak to the motion.
I had some statements. I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was previously residing in Penfield. I spoke to their sheriff where we looked at the videos together, and he told me that he would be conducting a search and not to address the matter to the plaintiff because he would need time to get 2 search warrants, and the investigation was never done. The next statement is also false. On December 27th, after the children's bath, Amelia Conley was heavily her private area, and when questioned who touched her potty, she said her dada. On January 1st, Evelyn Conley stated that her dad touched her on the couch. The fourth statement is false. CPS is not taking the proper steps to ensure the minor children's safety, and I did mention police involvement in the last hearing as well. The fifth statement is also false. Errors were made by the plaintiff. In early 2024, my mom threatened to call CPS on me because of the children's odd behavior, requesting that I get them checked by the doctor. I had the doctor examine them at their 2-year checkup, and almost 2 months later, the plaintiff was arrested for domestic violence. I originally withheld the kids because of the plaintiff's sexual preference for diapers and enemas, knowing that the plaintiff was not mentally stable enough for unsupervised visitation. And I withheld the children again after finding videos the plaintiff had watched of children being abused. And the minor children were sexually abused during holiday parenting time with the plaintiff. And I would like the court to consider changing the current custody orders and issue no further contact between the minor children and the plaintiff. Plaintiff should be held accountable for his actions regardless of stature or representation.
Court does believe that the plaintiff has met the VARCA threshold of proper cause, change of circumstances sufficient for an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter.
What is your understanding of what the parenting time is supposed to be?
Every other weekend and a day during the week, in the evening. Not my weekends, it's Wednesday through Friday.
Have you been getting your parenting time?
No,
Why not?
because she is refusing to let me see them.
Have you attempted to get your children from this couch?
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
Have you filed motions with the court to get parenting time?
Yes,
Has the court awarded you make up parenting time?
yes,
Most recently, the court awarded you parenting time in January of this year.
yes,
Did you attempt to go pick the children up for that make up parenting time?
yes.
What happened?
She refused to give them to me again.
Do you approximately know how many days you have missed so far as simply your overnights for parenting time?
20.
Ms. Putnam, how do you know Mr. Connolly?
He is my son.
And how do you know Ms. Couch?
She is Zach's former girlfriend and the mother of my granddaughters.
You heard him just testify that he has parenting time with your granddaughters, correct?
Correct.
Okay. Do you assist him in pickup and drop offs for
I
parenting
do.
time? Okay. What do you do in that regard?
I go with him and walk up to the door with him to get the girls.
Has there been occasions when you have gone with him to go get the girls? And anything happen in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park and we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach and we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the girls. His first visit that he was supposed to was, I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was gonna refuse to give the girls. Either she would not be home, he would text her and she would not respond, or if she was there, we'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and assisted that help in terms of actually getting parenting time to occur.
No, she just did the same thing to the police.
Okay, the order is dated February 4, 2025. And it provided for makeup parenting time in Christmas Eve, Christmas Day, 2025. It also provided that the plaintiff would have the children with him on January 29th, 2025 at 6:00 p.m. until February 9th.
I have another question to ask you, sir.
Okay. Let me clarify that because this is the order dated February 4th. Did you provide parenting time on the January 29th?
No, I did not.
Okay.
This is our fourth motion to try to get him parenting time. We simply want him to have his parenting time. With the threshold being met, Your Honor, and considering the behaviors, and I think it's going to be ongoing from this couch, we request that the children be turned over to him today that he have custody and parenting time with the children until the evidentiary hearing occurs. We'd request mom's parenting time be supervised. We'd also request the assistance of law enforcement to pick the children up. I believe they're probably with her mother, who's likely going to take the same stance as Ms. Couch and refuse to turn them over. Maybe give them the authority with a court order if she fails to do so, that she can be arrested. And in the meantime, Your Honor, we'd request a finding of contempt. Sanctions are doing nothing. You've sanctioned her $1,000, which she's a voice she's never going to pay. Doesn't have any impact on her. At this point in time, we request jail time, 30 days of jail time. Maybe that'll get her attention that she needs to follow your orders. Thank you.
Thank you. Ms. Couch, your closing argument.
I just want my kids to be safe. That's all.
Well, the court has heard again, the testimony in this case. The court will note that, again, that apparently there had been a denial of parenting time, which is not disputed by the defendant. In fact, she acknowledges that she has in fact denied parenting time. And court notes that as a result, she has withheld the children, that she's failed to comply with the order of.
But there's reason, sir.
Excuse me?
There's reason,
Okay.
valid reason.
Okay, ma'am, you're done. You don't have time to speak at this point. Okay, you've had a chance to testify, you had a chance to do a final argument, so you're done. The court, she failed to comply with the order of June 13, 2024 for parenting time. She failed to comply with the order of December 2nd, 2024 for parenting time. There was an order of November 1, 2024 for makeup parenting time and attorney fees of $500. Again, there was an order for makeup parenting time dated February 4, 2025 for makeup parenting time and attorney fees from the hearing held on January 27, 2025, that all four of those orders she's failed to comply with. The court has reviewed the file. There's been multiple show cause hearings. She has previously been held in contempt of court. She has previously been ordered to make up parenting time as well as pay attorney fees, as I stated, and she's failed to comply with any and all of these prior orders of the court. Her recourse is to file motions, have hearings in the event that there is some issue. The court will note that I am recalling from the last hearing where she had made allegations concerning the plaintiff, and in fact, she acknowledged at that time that there had been 2 CPS involvements and the CPS had not done anything as a result. She acknowledged that she had been in contact with the police, that they had not done anything as a result either. The court will find that she is in fact in contempt of court. The court will, as the plaintiff stated, he's entitled to 20 days of makeup parenting time, and that shall occur at such time as he acquires the care of the children. The court will note that, again, the prior rulings of this court, that she had done makeup parenting time on 2 occasions, as well as paying the attorney fees, that in fact she has ignored and refused to comply with those particular orders. So, ma'am, unfortunately, you leave me no choice, but the court will sentence you to 30 days in jail with the Calhoun County Sheriff. The court will further remand you to the care of the Calhoun County Sheriff, where you will remain until such time as the children are turned over to the plaintiff and until such time as you've paid the previously ordered attorney fees of $1,000. So, ma'am, you can go with the sheriff, and
Are you serious?
this matter is concluded. You're free to go.
Who's around here?
Oh,
No,
ma'am,
seriously.
Another 30 days for contempt of court. You're in jail for 60 days now.
No, what's going
If you
on?
keep going, I can go as long as you want, ma'am. She can stay there as long as she wants, I guess, until she has them turned over.
I'll draft the order in 7 days, Your Honor.
Okay, thank you.
Thank you, sir.
You're free to go. Have a good day.